On June 13, 1971, the New York Times published excerpts from a top-secret Pentagon study detailing United States government deception during the Vietnam War. 2 days later, the United States government, attempting to censor the newspaper, halted publication. In 3 weeks, the Supreme Court ruled in favor of the press in the most momentous First Amendment case in history. Freedom from prior restraints, or censorship before publication, had been considered a necessary liberty since the creation of the Bill of Rights.
During, for example, the reign of Henry VIII and Elizabeth I in England, there was a licensing of the press. And press licensing was justified by the government on the grounds that the printing press posed the single greatest threat to the crowned heads of Europe that had ever previously existed. So dissenting opinions disseminated through the press were very dangerous so far as kings and queens were concerned.
In 1765, English Judge William Blackstone wrote, "The liberty of the press is indeed essential to the nature of a free state, but this consists in laying no previous restraints upon publications, and not in freedom from censure for criminal matter when published."
So at the time of the adoption of our First Amendment, a prior restraint on publication was already regarded as an offense to free speech and free press.
August 2nd, 1964. War. Unbeknownst to U.S. citizens, their government had been escalating involvement in Vietnam since 1950. Government officials assured the public that the United States was winning. They were lying.
We still seek no wider war.
By 1968, a strong public opposition to the war had formed. Richard Nixon, Republican presidential nominee, claimed that he had a plan to get the U.S. out of Vietnam. He, too, was lying. Before Nixon's election, Secretary of Defense Robert McNamara commissioned a small task force charged with studying U.S. involvement in Vietnam and examining mistakes made. The study rapidly expanded and became known as the Pentagon Papers. Young war hawk Daniel Ellsberg assisted in the creation of the study, but as he learned more through his work, he became firmly opposed to the war. After efforts to show the papers to members of Congress failed to raise sympathy, Ellsberg gave them to New York Times reporter Neil Sheehan. Though Times editors and reporters were adamant about the need to publish, the Times law firm, Lord, Day & Lord, strongly advised against publication and could not represent the Times in court. If the government decided to fight in court, and government won, the company would completely lose its credibility, forcing it to shut down. However, James C. Goodall, general counsel for the Times, thought the paper was on the right side of the law.
I told them that under the First Amendment, they had the right to publish, and when they asked me whether they thought there would be a legal action, I told them there would be, but I thought we would win.
Arthur Ox Sulzberger, publisher of the Times, took his stance. The documents would be published, and the Times would find other lawyers to defend it against likely government action.
Do you feel, Mr. Sulzberger, that the national security is endangered as charged by the administration?
I certainly do not.
Can you expand on that just a little bit, please, why you do not think so?
Well, having read all of the textual material and vast quantities of the documents, I won't confess to have read every document in the place. I certainly arrived at the conclusion, and my associates did also, that this was not a breach of the national security. We gave away no national secrets. We didn't jeopardize any American soldiers or Marines overseas. Are you going to...
On June 15th, 1971, a New York City federal district court granted the Justice Department's request for a prior restraint against the Times. Never before had the federal government attempted to censor news before publication. June 18th, the Washington Post published its first article on the papers after receiving them from Ellsberg. Katharine Graham, publisher of the Post, decided to print, again against the advice of the paper's lawyers.
The Nixon White House goes into federal court in Washington, D.C. and tries the same thing, asks for an order from the judge to stop the presses of the Washington Post.
Ben Bradley, executive editor of the Post, pushed for publication.
Well, I remember when the outroar began that they said the Republic was endangered if we continued to publish. Well, we did continue to publish for 2 days after this. The Republic still stands. And if you read the judgment of Judge Gerfine in the New York court, he says very clearly that it is maybe an embarrassment to the government, but there is no vital national security issue involved in the documents already printed.
The case climbs through the federal courts at the highest rate of speed of any case that I know. Literally 20 days later, they're arguing the case in the U.S. Supreme Court. Normally, to get from the district court to the U.S. Supreme Court takes about 2 years.
Attorney General John Mitchell claimed that the Times and the Post had violated Section 793E of the Espionage Act, which guards against stolen government information relating to national security. However, the Espionage Act does not prohibit publication of stolen documents, nor does it mention classified documents. Furthermore, the government could not provide evidence from the papers that showed a clear threat to national security. The Post and the Times argued that the First Amendment applied in all instances, with the exception of printing information that could result in a grave and immediate injury to the nation or its people. 6-3. Headlines triumphantly announced the Supreme Court decision for the papers. In its opinion, the court stated, "Any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. The government thus carries a heavy burden of showing justification for the imposition of such a restraint."
There were a majority of the 9-member court that said, look, this is outrageous. No injunction of any sort should have been granted even to begin with.
Daniel Ellsberg was charged with theft, conspiracy, and espionage, but his case was dropped after the court found that the government had broken into his psychiatrist's office in search of hurtful documents. Both the New York Times and Washington Post publishers risked the credibility of their publications in taking their stand for freedom of speech. If the papers lost their readership, they would almost certainly go bankrupt. In addition, there was still a possibility that printing the material would harm U.S. soldiers. In the tense atmosphere of 1971, that could be seen as the crime of the century. Justice Potter Stewart wrote that the government could not enjoin a publication unless information would cause direct, immediate, and irreparable damage to national security. This set a legal precedent that is still used to uphold First Amendment rights of the media today. In addition, the standard deters the U.S. government from taking legal action against the media and reduces any freezing effect that opponents of the media might have.
It's all fake news. It's phony stuff. It didn't happen.
It's a fundamental part of the functioning of a democracy to have an enlightened electorate. If, in fact, the people who vote in those in power are not informed as to what those in power are doing, one cannot have a democracy.